So, and I urge you, my Lord, to put this kind of conduct to shame by stopping my colleague from participating in this proceeding. I hear the family has another advocate. They can appoint as many as 10. Whatever they want.
Can they walk out? Can we say that they walk out?
Yes.
Can those who are shouting walk out? Can I remain then with only advocates? I noted even as you left court last time, you made a lot of noise. Of course, I have not stopped transcription. Are we in agreement that you remain silent, no matter what your feelings are? You people, or I just say you stay out? Just tell me, how many want to remain silent from now on? Raise up your hand. So the rest would want to interrupt. Okay, officers who are in court, let me not emphasize. Whoever interrupts, just whisk them out. For those ones who did not commit themselves to honoring this court, to allow the advocates to speak. No matter what you feel, restrain yourself. Are we together? All I have spoken a lot of English that you do not understand. Tell them. Mr. Gatti? Ms. Awol? Ms. Awol? So if you don't respond, I'll assume that you are not participating and I can leave these proceedings. I can terminate the meeting for you. Talk to me if you have logged in. Miss Gogi?
Yes, my lady.
Okay, you're there. What about, I don't see Awol and Gatti. Mr. Gatti, talk to me.
Yes, I am present.
Good.
Yes.
Now, what about, who else? Mr. Mongeri?
Yes.
So what I cannot assure you, Mr. Mongeri, is this. That there are things you want to say about the advocate and you do not want people to...
I'll say them here.
They are where?
Yeah. I will disclose whatever it is.
You'll disclose it openly.
Whatever it is, they respond.
But only, but try to be as courteous as possible so that you do not unnecessarily attack counsel. Use your discretion when the court is the way it is. If it is not necessary, you leave it. If it is not in your papers.
Okay.
So I would want you to stick to what you have put there. There is nothing that you would be saying. I'm not defending counsel, but I don't think it is fair to ambush counsel with issues that are not there in the affidavit. So, Wamaitha?
Yes, my lady.
You are there?
Yes, I'm present.
It is you and him, I'm not defending you. I have no reason to defend you. But I'm only trying to insist that justice be done to both parties and also to protect this profession. You are both advocates of the High Court of Kenya. So let's avoid things that are likely to go that route that I don't want to mention. Yes. So we can proceed.
Yes, my Lord.
Just 1 minute, direct you. And for your information, this system is still open. The press are here.
earlier that we were not served with Ms. Morandes that used affidavits in support of Mr. Morandes' applications.
And orally doesn't mean that then you go to the contents.
My lady, the contents which are written in my application, in my supporting affidavit, are still the contents which I'm going to support orally the application.
Is it agreeable to you? You know what she's saying? That she wants to use that to argue, to reveal the contents of the affidavit in support and do it orally. Because you have asked to have it expurged. I'm wondering how now that is working. How is that one working?
My Lord, I thought that...
How is it working?
My Lord, I thought that this being a criminal matter, what Ms. Morane would be agitating would be her client's position.
In
So, in support of this application.
But it is not served on her so that she knows what to do.
Since they don't want to be served in an affidavit, because criminal proceedings are oral in nature.
Wasn't there a reason that you decided to do the application?
No, it's okay. It's because you gave us directions. And that's why we are doing it orally. Because they want to hear what we are saying, because it is their position. Majority of the time, that's what criminal proceeding is.
But she doesn't have it.
What she's saying, my Lord, is that...
Let her speak. Let her speak. Let her speak.
I've seen the affidavit.
Not you. Let her speak. Did you receive it? If you didn't receive, what do you want?
My ladyship, the same should be expunged from the court's record. Because I don't know the contents, I don't have it.
Have you checked your email?
Yes, my lady.
What is the date of the email?
Yesterday.
Yesterday. So you want to say that there is no email dated yesterday? Because the most you can do is to be allowed to see it, and then you are able to handle.
My ladyship, I've just checked my email. Present.
There is no?
There is no such response.
My lady, what I'm actually saying is, whatever Mr. Mongeni
Did you? You have said you served through
she
email.
has already made an application to have my affidavit expunged.
Counsel, let's have order. Let's have some order. What you said you filed in support and served through email.
Yes.
She's saying you said you served yesterday. She's saying she has just checked the email as I've told her to do it, and there is nothing like that.
Yes.
In all fairness. What should we do? What should we do?
I'm saying I'm in agreement. The affidavit can be expunged from the proceeding, but I should be allowed to have my submissions to the said application orally.
Is that agreeable to you?
It's okay, my ladyship.
Sorry?
It's okay.
Yeah, yes.
Because
That is how you are supposed to settle these things. You are advocates.
Because I'm also going to support her in the case, so we can proceed.
Great.
Then I don't find if there are counsels who are going to respond to an application they will not file an affidavit, then you must have limitations. Because if you
are saying I must. The court must.
There must be limitations. Because if there is a limit to her affidavit being expunged, we don't record anyway.
Okay.
And there are those ones who are supporting the responding.
Now you are advocates here. I do not have time, that luxury of time, to make a ruling on that.
Correct.
As advocates, you have time to think through what you want. In the meantime, I hear someone who is ready. Remember, there are people who are ready to proceed with their case.
Correct.
And some have logged in from out of the country. So I can always give you time, think through as advocates, see what you want to do with this. It should not be a war. Should it be a war?
No.
What is the most that can happen? I have not given you time to proceed. I will not proceed with it unless you are in agreement of how you want to proceed with this matter. Okay. Now, Mr. Kehara, we had someone who had logged in from out. It was for what time? 11:30. The other hearing? The other 12. And it is only 15 minutes to time. And I gave you all the time to think through. Now you have called me to argue, so that you can argue on how to proceed.
No, my lord, we are ready to proceed. For us to so file our documents, you can give them time to add whatever they want. More particular issues of law, case law, they can do that because they have not filed anything to support the facts. So Madam Morandi and my colleague there can only state what the law is because they have not filed facts to support whatever they want to say. That's the only thing, that's how they can be got because they had all the opportunities to either support it or not. That's the due process, you know my fault.
Wamaitha? Wamaitha?
Yes, ma'am.
You are in agreement with him? You seem to be consulting Mr. Gatti there. Is it Guto?
Yes. Mr. Mandela want to break his own committee. So I'm saying we are an argument, let them proceed. We are not opposing whatever they are saying. Let them present their case. Because they are here to present their plan. Because all these people, actually, it should not be a war between advocates. We are here to present plans. So, my opinion would be, let them proceed with their case. Let them speak on behalf of their plans, and we will respond.
How? On which, using what method? Can you use facts?
Yes, we will use facts.
You want to use facts?
Yes.
Then when you ought to have filed responses, if you are anything according to the directions that I gave, you ignore to do that, and then now you want to convert.
We'll be relying on because we are a team, we'll be relying on whatever she has filed.
Who has filed?
Whatever Ms. Wamaitha has filed, the response. I reply. She has replied. She has replied to the application. So we are just going to rely on that application that she has filed.
Let me get that as a consensus.
Yeah.
Morande?
I'm in agreement.
Being recorded and transcribed. Yes, Mr. Mangeri.
Yes, my lady, the application before you is the one dated 1st of April 2025, sorry. The application, my lady, is supported by the grounds on the face of the application and the supporting affidavits in support of the application sworn by Geoffrey Ndomo, the first defendant accused. My lady, from the outset, I want to make it clear that what this application intends to serve is what the constitutional requirements are in Article 49 and Article 50 of the Constitution 2010. And towards that end, my lady, the application is addressing a scenario of having a fair hearing, fair administrative action, and that the accused persons have their day without having to look at the back of their backs to see whether there is somebody else who may be ambushing them. My lady, I have enumerated in the affidavit the reasons why we want my colleague, Ms. Wamaitha, recused from this case. And the reason is because of she is conflicted. She is conflicted in the sense that, my lord, my lady, she has had to take instructions from the accused persons at one point. Before the arrest of the second accused person.
She had received instructions from
Yes.
all or some?
Nearly all of them, save for the last accused person.
That is the fifth, except
Yes.
the fifth.
Yes. My lady, at the time the second accused person was being arrested, it was at the behest of Ms. Wamaitha, who called him to a place and both had put him promised to buy him tea and lunch. And in the midst of that, she took instructions on what the second accused person's defense is, what he knew about this case.
Sorry, repeat that.
She took instructions on what the second accused person's defense is, because at that point she was trying to know how he participated in this particular offense. So there was disclosure of material privileged information. And on hearing the second accused, that's when she called the police to where they were. And he was arrested. She delivered the second accused person to the police, having taken instructions from him. The same thing happened. The other accused person was called as the third accused person by Wamaitha.
Are you representing the third?
Yes, I'm representing the third also, together with Ms. Morande.
Together with
Ms. Morande.
With Ms. Morande.
Yes. He was also called, and in the same manner, gave reliable information, gave privileged information to Ms. Wamaitha, and he was also arrested. Ms. Wamaitha at some point sent 1,000 shillings as lunch to the second accused. As a thank you that he has now come to her and that they have had a discussion. My lady, that engagement by my colleague, which now becomes unprofessional, persisted after the accused persons were now remanded at the prisons. This one is contained in the affidavit starting paragraph 10 through. Ms. Wamaitha, my lord, called the prison welfare number and requested that she wants to speak to the accused persons. At some point, this number was received by the second accused, by the first accused, sorry.
Wait a minute. So, when they were remanded,
yes, after the
Wamaitha called who?
Wamaitha made a call to the welfare number at prison and requested that she wants to speak to the accused persons. And the person who was on call from the representing the accused persons, who was first called, was the first accused person.
Seeking to talk to all
the accused persons.
All
yes.
the accused persons.
Yes.
Mm-hmm.
And the first accused person is the one that she engaged in that conversation. And a date was set for her to go to prison.
The second accused agreed to?
Yes, in fact, the first accused told her that we have lawyers and we wish that these advocates be involved in the discussion.
Who answered? Who was
the first accused?
The first accused.
Yes. So she is the one who told the Counsel Wamaitha that we are now having advocates. We would wish these advocates to be part of this discussion. But she declined and told them, no, it's not so much about these advocates. Something I want to talk to you people. And having a person who understands the law at that point should have been the first to shake off that particular conversation and desist from getting involved with this accused person. Because she knew now she is representing the family.
Mm-hmm.
So following on that particular phone call, Ms. Wamaitha proceeded to prisons and called the first accused person, who was brought to her.
Which accused?
First accused.
Mm-hmm.
They had a conversation with the first accused. Sought the first accused information on the offense.
Mm-hmm.
And now purportedly wanted to advise the first accused to plead guilty to the offense that she will help the first accused.
Mm-hmm.
This information was also passed to the second, third, and fifth accused persons.
Wait. It happened also to?
Second, third, fourth, and fifth.
That is second?
Second, third, fourth, and fifth accused persons. They were also asked to plead guilty.
Second, third,
And fourth and fifth.
fourth, and fifth.
Yes. They were promised that if they were plead guilty to the offense, they will be facilitated. And a figure was mentioned that was to be given. Through Wamaitha, ranging to 100,000. It is on an affidavit, my lady.
Ranging from?
You know, 100,000 shillings.
If it ranges from 100,000, then
For
it
each.
goes up to?
That's
if
the
it is a
minimum.
range.
That was mentioned. That was what was mentioned. I'll give you 100,000. Which will be given.
Just wait.
Yes. Which will be given and paid.
A minimum?
Yes, that was the minimum. And more other promises were made. The question for your leadership to ask is, with this kind of conduct, does it align itself with the calling of Ms. Wamaitha to being an advocate of the High Court, who is supposed to advise?
So what is the question?
The question you have to ask yourself and then answer is this. Is this conduct by Ms. Wamaitha in line or in tandem with his professional calling, with her professional calling? Getting information about a party she does not act for, who is a party against whom she's acting, is unprofessional. And my lady, that's why we say my colleague is conflicted. She has knowledge of privileged information from these accused persons. Which in the end, my lady, will affect or interfere with the fairness of this case. My lady, in the case of Waswa versus the Republic, this is petition number 23 of 2019.
Just 1 minute only. 1 minute only.
Yes.
You have full citation?
Yes, the petition is number 23 of 2019.
23 of?
23 of 2019 into brackets close to 2020 KLR at paragraph 77. The court had this to say, my lady.
It has to have names.
Yes, this Waswa versus the Republic.
Is that the full? Is that the full?
Yes, that's how it is cited. Waswa.
It is cited, it is reported as Waswa.
Yes, Waswa versus the Republic. The judge in that case observed
You tell me which court, whether the Court of Appeal, High Court, Supreme.
it is the High Court, or Supreme Court, sorry.
Yes, because we know the
Supreme
history.
Court. Sorry, Supreme Court.
We happen to know the history of Frederick Wasa case.
Yes.
So this is Supreme.
Court observation.
Okay. So if you have it there, because if you are putting a lengthy paragraph,
No,
I
that's
cannot.
not paragraph. I'm only quoting what concerns the participation of what counsel wanted to do.
So if you have the authority with you, in that authority is what paragraph what?
Paragraph 77.
In paragraph
77
77.
of that case. Now the judges of the Supreme Court say victim participation must not be prejudicial to and inconsistent with the rights of accused persons.
That is the head of
The court.
Okay. So it held that
Victim participation, ruling or counsel, must not be prejudicial to and inconsistent with the rights of an accused person. My lady, in section 9 of the Victim Protection Act,
so you rely on section 9.
9 of the Victims Protection Act, paragraph 2 of that particular section 9.
You had said you would take how many minutes in this application? I'm reminding you because I can remember offhand that you had said that you take how many minutes?
5.
And we have taken how much?
Around 4.
Paragraph 2.
Yes. It talks of the manner. I don't want to paraphrase because you will read.
I've just said I've said that you rely on section 9.
Yes.
Paragraph 2 thereof.
The catchword under Roman 3 of that 2 is that the participation of counsel for the victims should not be inconsistent with a fair and impartial trial. Now, from this conduct number, it is quite clear that Ms. Wamaitha has breached her duty as counsel. And she cannot walk.
The 1 minute remaining is over.
Is summary. She cannot walk on 2 roads with her 2 legs. My lady, I sat with these accused persons the last time we left court. And I want to tell you as their advocate, representing them, that they are worried, that they have a counsel who has been with them and is now feeding the prosecution with information. And their worry is, my lord, the provisions of the Constitution that requires a fair trial, which is a human right, is and has been breached by my colleague. If I were my colleague, let me tell you, my lord, I would have cheated this case at the point where that allegation was made. The motivation may be there for her, but her first calling should be her professional calling. So, and I urge you, my lord, to put this kind of conduct to shame by stopping my colleague from participating in this proceeding. I hear the family has another advocate. They can appoint as many as 10. Whatever they want.
Can they walk out? Can we say that they walk out?
Yes.
Can those who are shouting walk out? Can I remain then with only advocates? I noted even as you left court last time, you made a lot of noise. Of course, I had not stopped transcription. Are we in agreement that you remain silent, no matter what your feelings are? You people, or I just say you stay out? Just tell me, how many want to remain silent from now on? Raise up your hand. So the rest would want to interrupt. Okay, officers who are in court, let me not emphasize. Whoever interrupts, just whisk them out. For those ones who did not commit themselves to honoring this court, to allow the advocates to speak. No matter what you feel, restrain yourself. Are we together? All have spoken a lot of English that you do not understand. Tell them.
Koti nasema tuweze kuzingatia maadili ya koti na mali ya koti.
Have you understood? You are done.
My lord, that particular
You are done?
I'm finishing. That particular response is contained in paragraph 25 of our supporting affidavit, and it goes to the conduct of Ms. Wamaitha. The mobilization she has been doing.
Highlighted on paragraph what?
25 of their supporting affidavit. The mobilization she has been doing.
Paragraph 5.
Yes. 25 of the supporting affidavit.
I think you are done.
Yes. So I urge you, my lord, to maintain the sanctity of this profession by ensuring that our conduct as advocates should be within the parameters that I will lay down, and we stay clear of the lanes that have been properly prescribed, and urge you to uphold our application.
So we have agreed that you'll use which one? You use the affidavit by Mongeri. And Ms. Wamaitha, you have said you have no issue with that. Eh?
No.
What about Gogi?
Yes, my lady.
Did you have any issue?
Yes, my lady. I can hear you.
I've asked a question. Do you have any issue? Have you followed what we have said?
Not really. I don't know what parties are contesting on.
If you don't know, then leave it. If you don't know, leave it. It is the issue. It is the issue between Wamaitha, Madam Wamaitha, and Mr. Mongeri.
Okay.
Their clients, yeah. So they.
Right.
I'm not supposed to recap for you because you are supposed to be paying attention, eh? You'll have no input. Let me put it that way.
No, I will support the application by Mr. Mongeri.
So
I wish to support.
so you just support. How will you support? Will you address the court on the same?
No, I will rely on whatever Mr. Mongeri addresses court. I will rely on that. I will not be filing any.
My lady, video commission.
Wait. But what you will not do, Madam Gogi, is to go, you can simply say, I support.
Yes, my lady. What, yeah, I will go by that.
Who else wants to talk to me?
Yes, my lady, Miss Award, for the fourth accused person. I also support Mr. Mongeri's application. Need to go on record.
Are we now full house? I have heard everyone so that we start.
Your Lordship,
Yes, Mr.
with your kind permission, my name is Makori. We appear together with Mr. Wamaitha for the family.
So basically then you are relying on what she has filed.
Yes, we rely on the responses to the application.
Have I locked out anybody else? No. So I think we are now in agreement, Mr. Mongeri.
Yes, my lord.
Okay. Try to speak as you start. I just say anything, then we test whether they have heard you.
Yes, my lord, my lady, the application before you is dated 1st of April 2025.
Stop there. Ms. Goge, have you heard him? Have you heard Mr. Mongeri?
Yes, I have.
So let me turn it, let me turn the camera. Because I'm using the laptop, you're not using the screen used by my court assistant. Is that okay? Is that okay, Gogi, and the rest there? Can you see the court?
Yes, I can see the litigants.
You can see the courtroom, that is. You can see Mr. Mongeri.
Not really. I can just see yes, now I can.
Yes.
Now, but I suppose that you are comfortable proceeding even if you don't see me, because there is evidence that I'm here. And that is my voice. You trust that, huh?
Yes.
Good. Wait, just wait now so that we can. Response. All we are saying the one support, I support.
My lady, yes, I support Mr. Mongeri's application. Only to add just one statement. that, my lady, the role of prosecuting a criminal matter is solely placed on the Director of Public Prosecution. The role of an advocate watching brief for the complainant is limited. And I place my reliance on Section 9, Clause 2,
Of
Section 9 of the Victims Protection Act.
which he has
Yes.
talked about.
Yes.
So you support?
That is all, my
Right.
lady.
The other in support? The other in support?
They are online.
Hey, no, I speak so loudly that I'm sure they can hear.
Okay.
Who else is in support?
Who is for the second accused, I support.
Great. Who else?
My Lady Gatti, for the fifth accused person, I support the application by my senior Mr. Mongere.
Who else? Full house. Is there anybody else left? I think we have that all done. Who is left?
My lady, I forgot one thing.
I didn't ask you that. I asked who else is supporting.
Okay. But I will do it in rebuttal. Because I want to say that we may call Ms. Wamaitha as a witness at some point.
Have you, is it in the affidavit?
Yes.
If it is, leave it.
Yes. You're saying a lot that it is.
Is it in the affidavit?
Yes, it is. You will
Leave it.
Yes.
Is there anybody else who has not been, who is supporting and has not spoken? Great. Wamaitha?
Yes, Your Ladyship. Your Ladyship, the application is opposed by two affidavits sworn by myself, and that one of the widow, one Margaret Njoroge, both
Wait.
they're dated 7th of April 2025.
They are sworn on the same date.
Yes, they were sworn yesterday.
Two affidavits.
One sworn by myself, and the other one is sworn by the widow of Richard Otieno, deceased, who is the instructing client in this matter, both dated 7th of April 2025.
They are dated
7th of April 2025.
2025, yes.
Yes, I believe the court's order.
Did you approve?
Yes, the order is
With access.
Your Honor,
Let's also know
yes,
how much time you are taking.
Your Honor,
We had agreed on timelines.
5 minutes.
5.
Your Ladyship, I believe I'll be opposing this application by the defense counsels on the following grounds and reasons.
Are they there?
Yes, Your Honor, in my reply.
So you rely?
Yes, in my reply affidavit, in its entirety. That Your Honor, an advocate has a right to act for any client and the client has a right to appoint an advocate that he or she desires. Actually, it's a constitutional right.
He has an advocate has a right to act for any
Clients, any client,
Mhm.
and any client has a right to appoint an advocate he or she desires to represent him or her in any matter. And therefore, your lordship, I submit that it is a constitutional right to be represented, the client should be represented by counsel of their choice. And Your Honor, the instant orders that are sought by the defense counsel in the application is to have me barred from appearing for the family in the murder trial. And Your Honor,
to bar you from.
appearing for the family in the murder trial, I believe your leadership infringes the right of representation. The counsels for the defense have submitted to this court that there might be conflict of interest. And your leadership, I believe it is true the right of representation will be limited in certain circumstances, and where possibly that I, as an advocate, being called as a witness to present a case or a conflict of interest for that matter. And Your Honor, there is no indication before this court that I'm likely to be called as a witness in this murder trial. Neither have I recorded a statement with the police
That you are likely to.
be called as a witness in this trial. Neither have I recorded any witness statement with the police. Not the prosecution have given any indication they intend to summon me in this particular trial. Your Lordship, the applicants here.
You have not been subpoenaed? Sorry? Okay. There is no evidence, you have not recorded statements with the police or DPP. And
any indication that they intend to summon me during the trial.
so there is no indication that you are likely to be called as a witness in the trial?
Yes, trial.
Yes.
That the applicants, your Lordship, who are seeking to have me disqualified from launching a brief for the family in this matter, must of necessity provide a proper basis to the court to enable make a determination. And your Lordship, in response to me having meeting the second accused person and having lengthy talks regarding the matter, and even agreeing to represent him in this court. The relationship is false, no evidence has been tabled, nor executed before this honorable court.
The allegations of meeting
The second accused person and having a lengthy talk regarding this matter, the instant matter,
which accused?
the second accused person.
Mm-hmm.
And having a lengthy talk regarding the instant matter, and even agreeing to represent him in court. Your Honor, my leadership is false, since no evidence has been exhibited before these honorable courts. And also, the leadership has submitted the argument that there is a client-advocate relationship. The argument that there is a client-advocate relationship between myself and the accused person is a misplaced argument. In that, for instance, no demonstration that I was paid.
Relationship with who now?
Advocate-client relationship.
With who?
The second accused person. Is a misplaced argument. For instance, no demonstration that I was paid legal fees to retain my services. And neither did I draw any documents on behalf of the second accused person.
All any fees or what?
Any documents. Equally, Your Honor, my leadership, there is no evidence that I call the police officers to have the accused persons arrested by the DCI. Simply because it's the duty to arrest any person is the work of the police officer and not the work of myself as an advocate.
It is the duty of?
The police officers.
To do what?
To arrest any person.
So now you are saying there is no evidence that you called the police to arrest the accused persons?
Yes.
That duty is placed on who?
The police officers. That duty is for the police officers and not myself as an advocate.
No, I think, okay, I'm not interrupting, but the issue that came up is not that you arrested, but that you called the police to arrest and handed over the accused persons to the police. Is that what was, that is the issue? It's not that you arrested.
Yes, Your Lordship, and I believe that it is. I want to tell this court that is false. Because never have I met the accused persons there before until I came to this court.
So you hadn't met them before before you appeared before this court? Wait a minute.
And I believe that no evidence is to that has been tabled before this court.
Done?
Just 1 minute. Actually, all the other allegations, Your Honor, cannot be substantiated before this court. And I believe, Your Honor, some of them, for instance, I feel they are personal. If you read paragraph 19 of the applicant's affidavit.
Paragraph?
19. If you read from paragraph 14.
So you refer the court to, do not, are you the one who is now speaking, or it is Wamaitha? The most you can do is to direct her to where? Counsel. Not substantiated.
Yes, that is from.
Then you're saying you're asking me to you are particularly paragraph?
That is paragraph 14 to paragraph 19. The applicants.
Paragraph
19.
We start with 14 or 19?
19.
Paragraph 19?
14 to 19.
That is what I asked you.
Yes.
From which one to which one?
14 to 19.
Yes, paragraph 14 to 19.
Yes, actually there are unsubstantiated allegations. Because, my headship, the issue of payment of 100,000, if that was done, why would we have used to report to the relevant authorities? That is the ESCC. We have the police and so on, because it shows that the advocate wanted to guide them. Further, I want to read paragraph 19 verbatim of this concept.
Is it paragraph 19?
Yes.
How lengthy is it?
My lady, avoid is that because of the directions you give that we don't
Yes.
become personal.
Wait. Okay, now, I'll look at it. You have said
Paragraph 19.
14 to 19.
Yes.
You want to put emphasis on paragraph 19. That would suffice. But he also, he had mentioned the 100,000.
That one is okay.
That one is okay.
Paragraph 19.
You see now, I don't have the application here with me. I'll access online. But you remember what I said about maintaining the decorum and etiquette in regard to this noble profession?
True.
Yes, so that if you retain, I'll surely look at it.
Yes.
So you said, okay. You said, why did they call ESCC?
To report that I was about to bribe them with 100,000 or any other relevant authority for that matter. Because corruption in Kenya is a crime.
Okay, we have said that you emphasize paragraph 19.
Yes, the feelings person, yes, actually that I feel aggrieved.
It says that paragraph 19, it is of the affidavit.
That is on the applicants.
On the application or the affidavit?
The application. Your Honor, in summing up, I wish to submit that a client has a right to be represented by the advocate of his or her own choice. Your Honor, I have a track record that will be captured in the sworn affidavit of Margaret Haki, who is the wife of the deceased, that I used to represent the deceased.
So you... in paragraph or the whole or in the affidavit? By the widow?
Yes, the deceased, even when he was alive.
Hey, the minutes.
I'm doing the work, I'm doing the representation for home, because the family cannot be able to hire a lawyer. It's very important for the court to know that.
You are appearing for the family pro bono.
Because they cannot be able to hire a lawyer because of their financial constraints and the economy. So, Your Honor, the application is made in bad faith. Full of malafidus and has not met the threshold.
It is in bad faith and
Malafidus. and has not met the thresholds for the orders sought, that the orders to be sought to be granted. And should be dismissed, costs to the applicant.
Should be dismissed with
Costs
costs to the applicant.
to the respondents.
Yes, Leon?
That's all.
Yes, you're welcome. So, Mr. Mo,
Your
This-
Lordship,
wait a minute, just wait a minute. We want to have some order. Whose application is this?
Yes, I want to support this woman.
Or you support her?
In that application has been made to have a request.
This is Mr. Guto. You just say that you support,
Yes.
just like the others did.
And I only want to make, that's what will take 1 minute. Your Honor, Mr. Monge's application is relying on the testimonies or affidavits from accused persons in this matter. And that is the reason why the court should warn itself. Whether that...
But you have already received statements.
Yes, I'm saying.
Have you already received statements from who?
Yes, I
From who?
I have looked at the...
Okay, let me get it.
I'm looking at the application that is before you.
Yes.
And the supporting affidavit.
Yes.
And I'm saying those supporting affidavits have been made by the accused persons in this matter.
I think that was a warning line. And my colleague cannot comment on this. It can only say he supports. And
Wait a minute. Just wait a minute.
Yes.
They are made by accused persons.
Yes. So the court should warn itself, even when it is entertaining those affidavits. Because what is before this court?
The affidavits were sworn. You see, I don't have that application with me, Mr. Mungeri. The affidavits are sworn by accused persons.
Yes, it is there.
Okay.
And first, Your Honor.
Wait a minute. You urge this court to do what?
So that goes to the property value.
You urge this court to do what?
That goes to warn itself. I want the court to warn itself.
On what?
Considering those affidavits, it should warn itself because they have got an interest in this matter. And you don't even know the reason why.
While considering the application?
Yes.
Okay, done.
Secondly, Your Lordship, what is before this court is a matter trial of the state against 5 accused persons. And not Mrs. Wamaitha. Mrs. Wamaitha is not at the trial in this court. And even some of the reasons, Your Honor, you look at paragraph 14.
You cannot comment on those paragraphs. I will object.
I'm not even writing that. I'm writing something I omit. Let's not.
I support the application on those grounds.
Advocate, I thought I give directions properly. You just say I support, and that is it. Okay, I allowed you to make that comment because nobody else did made that comment, that the statements are recorded by the accused person. So simply to warn the affidavits, so that just to warn myself.
Yes.
Just that. That is the farthest I've gone. Next. Who else?
yes, Your Lordship. Your Lordship,
Yes.
I'm Makori. We were appearing together with Ms. Wamaitha.
You support her?
Yes, but I want to give some additional.
Additional on what? Additional on what when there is no affidavit? You had my directions. Did you hear my directions?
I had your directions.
You can only put a point of law, any issue to do with the law, nothing else.
Yes, and that's exactly what I want to do.
Let's hear.
On behalf of the family, we are stating that under the Victim Protection Act, Section 9, A victim has a right to be presented at their trial, either in person or through representative, and we are submitting that Ms. Wamaitha is appearing on behalf of the family because she was appointed by the family, and all along she has been appearing. Even when this incident appeared, she appeared on behalf of the family. So at no point Ms. Wamaitha has taken legal fees on behalf of the accused person. Also, Your Lordship, in the case of Ruto versus Republic.
Wait. Which case is that?
The full citation is Ruto versus Republic. Otieno and another as interested parties. Otieno, in brackets, intended interested party.
Okay, what is it, how is it reported? It is faster, or it's easier to record. How does it appear? Is it reported or unreported?
It is reported. It's on Kenya law.
Reported as?
Ruto versus Republic. Miscellaneous Criminal Revision E075 of 2023.
Division E?
E075 of 2023.
E075 or 25?
2023.
E0?
E075 of 2023.
Paragraph now, which paragraph are you relying on?
We relied paragraph 75 of that case. Your Lordship, I should not read that paragraph. The court will access it for the issue of time.
I'm being reminded because I reminded someone when you quote a case, you tell us which court handled. It makes our work easier. It is a decision by High Court, Court of Appeal, Supreme Court.
It's High Court, but the justice agreed.
Aburiri.
Yes, Your Lordship. And in summation, Your Lordship, we state that the application before you really has not been substantiated, however, has made allegations without support of any evidence to tilt or to bar counsel appearing for the family. And it's a submission that there is no conflict of interest and that the right to represent the family should not be limited. And we implore court to dismiss that application.
Who else? We are done. Those ones, we are done with your side. Wamaitha. The most you can do is, I'm still limiting your time, so that we have everybody. There are people who, yes, and even 1 minute is simply to maintain, possibly you maintain what you're saying, and raise only 1 point or 2.
Yes, only 3 points. I will start with what Mr. Buto talked about, you worrying about the parents. As an advocate, he should be reminded about the presumption of innocence. Nobody has found this person is guilty of the offense, and this court will worry what they are reading. So that was so basic. Number 2 is what my colleague Mr. McCauley has said. The authority has submitted is persuasive to you, made by a judge of equal jurisdiction. Let us start with the one that we served you from the Supreme Court. Finally, in Ms. Wamaitha's submissions.
Wait, I've lost that floor. Just 1 minute.
My lady, finally, in Ms. Wamaitha's submissions, she did not deny meeting with her persons in prison, only denied receiving a phone call.
Wait a minute. Hey, are you able to open this door for me now? For some
Pressure.
Yes, the court is packed. Are you laughing, Mr. Yeah, it's the problem is that you have fixed this one, and I want to. Okay, it's a bit. Well, I'm the only one who is feeling that stuffy. You do.
That's why I want to finish quickly.
Please do. That is why I limited you.
Yeah.
It's a bit stuffy in here. Yes, so some of us are not able to, are not getting that fresh air. So, okay, just wait.
Yes.
That it is persuasive, that is where I am.
Yes,
there is no denial.
Yes. There is not in denial that the counsel does not deny meeting these persons in prison. Our only issue is that she can meet any client. And we presume that she was also treating these ones as clients.
Wait. I think you are done.
Yes, and my lady, we pray that for a fair and practical hearing, Article 50 and 49 should be able to guide this court to ensure that at least even a mention from an accused person or fear.
So what are you asking? Because I think those arguments you have used before, we can't repeat.
You allow the application, we move on with this trial. We cannot be held at ransom by Maida or Maida's participation.
for that participation. And can we now give, I think that you know about recess, of course. And what is the real urgency in this matter?
It is the board application form.
The board application, you see, it was put on hold because of all these, So, and you cannot assume that I'm going to carry a whole box of files during that holiday. It is not even lengthy. It is 2 weeks. I think it is only 2 weeks. 9 to 20. Is it 22nd?
22nd,
yes. 9th to 22nd. I noted like it's 2 weeks. Out of the 2 weeks, there is 1 week where we are attending, I think, yeah. So I can't carry those files to Mombasa so that I write this and you get it as we open. Now, now based on that, we can move to which date, Ruto? 15. The diary keeps moving because, as you are aware, you keep filing certificates. You keep filing certificates as we move on. That is how the diary moves. So this, we indicate here that there is no early date. No early date. Early date. Following, considering the recess starting tomorrow. So now by consent, we say now it is by consent that you come on which date? 15th. Let's agree that it is convenient to you.
It's okay.
May. It's not that there are no other files. Of course there are.
It's equally convenient.
15th of May. So accused remanded in custody.
Awesome.
Thank you so much.
Thank you so much.
Those raising their hands, this court is neutral. You have advocates. If you want to meet them, you'll do so where? In the cells. Are these your clients?
No.
Watu wamesimama hapo mwisho ni nani? Wewe ni wa kesi gani? Ni kesi gani? Wewe. Are you in this case? Yes. What is your name? Dennis. Which file? Okay, Dennis. Okay. Don't laugh at Dennis. He's someone who has come to seek justice. You have nothing to do with the file that is we are dealing with. You are not Geoffrey, or Peter, or Joseph, or Stevie, Evans. None of those names are yours. Okay, then hold. I'll come back to you. So, I've finished with the file that I'm handling. Thank you so much.
Thank you, Dad.
And now when he's on his feet, your motorbike was stolen. Now you are supposed to appear in which court?
It means that his motorbike was an exhibit in this case.
An exhibit in this case?
Yes.
And who is he?
I think he better directed to this.
And who is he? He said he's not. Those are not his names.
Yes.
If you know him,
Yes.
liaise with him.
Address.
I don't have I don't have his issues. I don't have those facts. But he's trying to raise his issue. Mr. Kihara is here for DPP. You can raise the issue with him. Anybody else? Yes, I go now to the other files. Asanteni sana.
Okay.